Good morning. I want to thank Stanford Law School, the Rock Center, Dean Dan Siciliano and his Rock Center staff, and Marcin Said for their excellent efforts in producing the Worksite Immigration Compliance Symposium today. I'd also like to acknowledge Greg Wald, my co-panelist, and the efforts of the co-sponsorship of the Northern California chapter of the American Immigration Lawyers Association. In writing the book, Immigration Compliance Auditing for Lawyers, our research showed that the I-9 platform would continue along with Homeland Security's commitment to E-Verify and the IRA document reduction provisions of that amendment. Currently, attorney auditor certification of I-9 audits may be necessary for Sarbanes-Oxley required disclosure, and the best example of that is the recent Chipotle 10K. The condition of civil or criminal settlements, and the example of that is the IFCO non-prosecution agreement. We will hear more about IFCO in the balance of the symposium. And we also know that attorney audit certification is necessary as a condition of ICE image membership. If we look into our crystal ball, we know that SOX and Dodd-Frank statutes require the attorney-led compliance audits. CEO certification will surely be an integral component of any future legislation. What is the key to the attorney compliance audit? And the answer is remediation. Attorneys are an integral part of the immigration compliance audit. The reason for that is attorney-client and work product privileges, the need for remediation using the virtue memorandum that we will talk about later, the use of defenses including the statute of limitations, and the need for reduction of liability for an ICE notice of inspection. The ABA book represents an audit system. What resources are found in the ABA book? You will find an employer audit documentation list. This is a sample list that would be provided to employers at the beginning of an audit. There's a reference document list that would enable the auditor to discover missing I-9 forms. The book also contains a chronological I-9 form and list table. And integral to the effectiveness of the book's structure is an I-9 audit checklist. That checklist is found at page 138 of the ABA book. Also, I'd like to point out that there is an auditor's guide, a step-by-step version of the auditor checklist that gives you basic information as to the nature of the substantive and technical and procedural errors that the auditor should be looking for. Also, what we've done is something that we're very proud of. We've made a composite list of substantive and technical and procedural failures, basically integrating the 2008 ICE memoranda with the virtue memoranda to come up with a up-to-date version of that 1997 policy. Also, please note that the book contains the entire virtue memorandum with all its appendices. Also in the book's appendices are all the major penalty memoranda. As I've said, remediation is the crux of the I-9 compliance audit. The concept of remediation is found in the Okaho decisions. The cure of substantive violations for mitigation of damages, application of the general good faith defense, and to begin the running of statute of limitations for certain penalty provisions is key to the book's structure. You will see that the external auditor recommends remediation which extends to all potential violations under the Immigration and Nationality Act. What are the components of the immigration compliance audit? The audit contains the Form I-9 audit, the Compliance Program audit, the Liability Audit, and anti-discrimination and unfair immigration-related employment and practice auditing. The external auditor determines and reports whether the retained I-9s contain substantive versus technical and procedural errors, so important to the virtue memorandum's maintenance of the good faith paperwork defense. The auditors cross-check the I-9 forms against employment records for missing or questionable I-9s, check for paperwork, timeliness, knowing employment and re-verification violations. The auditors will recommend remediation and audit corrections. Important to note that the scope includes both intrinsic and extrinsic factors. The Form I-9 audit requires attorney auditors to determine whether the retained I-9s contain substantive versus technical and procedural errors and evidence of knowingly hired or knowingly continuing to employ charges. Auditors will cross-check the I-9 forms against the payroll records and try to determine whether there are missing I-9 forms. Importantly, the auditors will recommend remediation plans for the employers to correct I-9 errors. There will be specific recommendations for the employer to correct those deficient I-9s, including tardy verifications for missing I-9s. Moreover, there will be mitigation for potential violations to minimize liability for penalties. The external attorney auditor will supervise the employer's remediation efforts. Auditor determinations in I-9 audits require the auditor to make determinations as to the running of the statute of limitations for paperwork violations from the corrections of the I-9s, timeliness violations from the second and fourth day of employment, and knowingly hiring or continuing to employ violations from the termination of the employee. The scope of the external I-9 audit depends on both intrinsic and extrinsic factors. The intrinsic factors exist in every audit. As the book shows, there's a chronological distinction on which I-9 form is to be used. Remember that every employer has the legal duty to verify every new employee hired after November 6, 1986. Moreover, there's a form and list chronology. There have been 6 revisions of the Form I-9 since its initial 1987 publication date, but only 3 significant changes to the list of acceptable authorization and identity documents since that time. Moreover, there has been a prosecutorial discretion policy for the use of the 1991 Form I-9, including the use of the accompanying lists A, B, and C since December 26, 2007. So, to repeat this important date, December 26, 2007 is the end of the prosecutorial discretion policy. After that date, the 1991 form should not be used, and auditors must keep that date in mind. That is an important intrinsic factor that exists in every I-9 external audit. Moreover, the auditors will recall that the virtue memorandum treats timeliness violations that occurred before September 30th, 1996 as substantive failures, but also recall that those substantive failures will be barred by the 5-year statute of limitations. Auditors will remember that the 1991 version of the I-9 form and the accompanying lists of documents to be verified stayed virtually unchanged until May 31st, 2005, a period of over 13 years. Moreover, auditors will also remember that the unexpired document interim rule, which incorporated IRA's document reduction, was not implemented until April 30th, 2009. The extrinsic factors are found in the employer's answers to the auditor's questions and the documents provided according to the sample checklist at page 104 to 106 of the book. Those extrinsic factors include ICE image program participation, E-Verify program membership, previous government IRCA I-9 inspections, Sarbanes-Oxley compliance, and the enforcement history of the particular employer. It's important to remember that integral to the effectiveness of the audit is the IRA good faith paperwork violation defense. The Virtue Memorandum was the 1997 policy which implemented the IRA good faith paperwork good faith defense. That memorandum treated the effective date of September 30th, 1996 as the cutoff point for substantive failures, for timeliness failures to be treated as substantive. After September 30th, 1996, timeliness failures should not be the subject of a notice of intent to fine or a complaint unless the 10-day business day good faith notice and correction opportunity is afforded qualifying employers. Another important part of the external audit is the compliance program audit. Compliance programs are crucial for proper corporate governance and risk avoidance. Compliance is a growth area of concern in the largest companies, with general counsel often expanding the responsibilities to chief compliance officers as well. In the compliance program audit, external auditors will determine whether written compliance manuals and training programs are compliant and up to date. They will check whether the I-9 verification and retention policies are current, whether anti-discrimination is effectively represented in the programs and policies, contractor liability policies, FAR Verify government contractor policies, and auditing for compliance to state law. It's important for the external auditor to determine whether the company's immigration law compliance policy manual provides its human resources employees with clear guidance on the various procedural requirements and record-keeping provisions, including H-1B posting and benching and public access requirements. Another panel that follows this one will discuss the liability audit, but this overview would be remiss in not telling you that liability auditing assesses civil and criminal penalty liability under IRCA, including violations of the prohibitions against knowingly hiring or continuing to employ unauthorized aliens, as well as liability under anti-discrimination and unfair immigration-related employment and practices laws. The reason why we're here today is to set the groundwork for the external compliance audits that are sure to come in the future. What are the principles of compliance auditing? First, we know that we must have an engagement agreement between the auditor and the employer. The importance of the engagement agreement cannot be underestimated. Within the engagement agreement, the parties will define the scope and objectives of that audit. What I'd like now to do is to discuss with my co-panelist, Greg Wald, some of the principles and ethics of the external compliance audit. I give you Greg Wald. The scope changes from audit to audit. What are some of the internal intrinsic factors or the extrinsic factors that the external auditor should be aware of?
Well, internal factors would be, again, are you auditing all of the I-9s? Are you simply auditing the I-9s? Are you covering the whole scope of their immigration compliance? Are you going to be auditing as part of this other immigration areas, such as, let's say, compliance with the Department of Labor LCA rules? So again, it's going to the scope. You're also looking potentially at the client's procedures and policies. Do they have a internally published I-9 compliance policy? Who's responsible for completing the forms? These are all some of the very important factors that you're going to consider in an audit. It's not just, it doesn't have to be simply just looking at the paper going down the checklist, because if, again, to get a complete audit, you want to be able to provide the client with enough information so that they can not only mitigate current or potential liabilities, but also embark on a program to mitigate liabilities that have yet to occur by instituting proper compliance and so forth.
The principle, Greg, of the competent auditor, certainly the folks that are here today and that are listening to this videotape will have a leg up on the training that a competent auditor needs. Can you tell us something more about the background of competence and independence as an ethical guideline?
Well, I guess when you think about it, the interplay between auditor and attorney is to a certain extent can be conflicting. As an attorney, you've got certain ethical duties to your client regarding confidentiality, just to name a few. And as an auditor, the scope of your engagement might be beyond, or your duties might be beyond your client, to the extent that third parties, let's say if you're a publicly traded company that's disclosing the results of an audit, may be relying on the results. So if you're certifying the condition of company's immigration compliance, again, the question becomes, who do you owe this duty to? So in this particular context, it is a balancing act, and again, it goes back to the scope of the engagement. What are you being engaged for? And whether this is going to be an audit that's going to be relied upon strictly internally or otherwise. And so that's very important, so that you're balancing, again, your ethical obligations with the guise to be an independent auditor as well.
So we know that there's no national standard for external immigration auditing, but certainly we all can start the training and the CLE that would lead us to competence. What are some of the aspects of auditor training that you would expect in the future?
Well, first and foremost is a command of the law, the regulations that pertain to I-9 compliance and immigration compliance, 274 of the Act and 8 CFR 274A. But it's more than that, as we know, without a set of guidelines and to a certain extent without regulations, at least as to the substance of the Virtue Memo and regulations that basically cover this, it's an understanding and keeping up with all the material, frankly, that's covered in your book. But the point is that keeping up with the constant evolution of I would say the principles of auditing, how the government at the given time is viewing or regulating, I should say, the requirements, the sanctions, et cetera.
Let's start our auditor training today.
Right?
Today. Let's talk about one of the key elements of an external auditor's training, the statute of limitations. We've already seen that ICE has recognized, and so has OCAHO, that there is a General Administrative Procedure Act 5-year statute of limitations for civil penalties. Can you tell us some of the aspects of the statute of limitations that you expect to be included in auditor training?
Right. So you want to look at and see, when is the statute going to run? In the context of a paperwork violation, an error on the I-9, the statute of limitations is not going to run until, or begins to run, once the error is corrected, or the employer is no longer required to retain that I-9. And as a reminder, probably to everyone here, the retention period for an I-9 is the later of 3 years after an employee is hired or 1 year after termination. The other statute of limitation regarding knowingly or continuing to hire an unauthorized worker basically runs until termination of employment. We had discussed actually my theory of whether you could make an argument that during the course of employment, if an employee, quote unquote, cures their unauthorized status, whether an argument could be made that the statute runs from the point of cure. But that's an interesting debate between lawyers. I guess it remains to be seen in the midst of an ICE audit how successful you would be, at least in the eyes of ICE, up until the point maybe you got before the OCAHO.
The statute of limitations for timeliness violations not only depends on the 5-year statute, but it also depends on the date of hire?
That's correct. That's why the date of hire is so important. It runs in Section 1 from the day after hire, from the 2nd day of employment, or from the 4th day of employment regarding Section 2, because that goes back to the obligations to complete Section 1 on or before the day of hire, and the obligation to complete Section 2 within or after 3 business days of hire.
And just as a reminder, ICE has also recognized that the E-Verify program now allows the 2nd business day and the 4th business day as beginning after the 1st day of hire. So you have the Thursday rule now recognized by E-Verify and now ICE.
That was one nice thing about E-Verify, yes.
So was there a dispute between ICE and OCAHO on whether the filing of the complaint or the NIF tolls the statute?
Well, based on current administrative case law, the filing of the complaint, not the NIF or the notice of intent to fine, causes the statute or tolls the statute. So what's significant about that is it's several months or possibly years could elapse between the beginning, let's say, of a I-9 investigation, which would be the NIF, and ultimately with the filing of the complaint. So during the NIF period and while you're dealing with ICE and their auditors, the statute is continuing to run. So that is important.
So only the complaint tolls
Correct.
the statute of limitations.
Correct.
The next two items on the PowerPoint in front of you are really the key to remediation and really the backbone of the book. And it actually, again, springs from the Virtue Memorandum, but also from its interpretation of IRA's effective date. IRA's effective date was September 30th, 1996. So that's another one of those intrinsic factors that the external auditor has to remember. Those timeliness paperwork violations that occur before September 30th, 1996 are considered substantive. But luckily, all those 5-year problems are gone because the statute will have run on prior to 96 timeliness violations. After September 30th, 1996, you still have to look at the 5-year statute, but the key thing is that under the Virtue Memorandum, the timeliness violation is technical and procedural and is curable. So,
except for Section 3, right, under the Virtue Memorandum.
And I've talked to Paul about Section 3 as a non-statutory paperwork. It doesn't exist in the statute. And so Section 3, again, if you're charged with a paperwork violation for Section 3, there's something really wrong because it's not in IRCA. So we see that remediation is the key to the external audit. It allows the correction of sanctioned violations, including substantive violations. It encourages the external auditor to report back to the employer so that the employer does the remediation, not the attorney, and that the running of the statute of limitations will be affected, especially for paperwork and knowingly employed violations. It allows mitigation of penalties. It preserves the general good faith statutory defense. And again, if you see at the very bottom, according to ICE policy, substantive violations cannot be cured for the paperwork good faith defense. But that's the difference between an external audit and the ICE audit. The remediation methodology in the book, after you've conducted the external audit, attorneys, you're going to prepare a remediation memorandum back to your client, the employer. In that, you're going to talk about how the employer's staff can cure the both substantive and technical violations that have been discovered. And the remediation steps are actually outlined in the book. So missing I-9 forms are discussed at page 162 to 165. Timeliness violations are also discussed in the book. Knowingly hired and continuing to employ violations are at 167 to 168. And the remediation of paperwork violations is at 169 to 170. We do have time for questions if you'd like to come up to the microphones. The most important aspect of the external audit is remediation. And it's a new idea that this should be done remote in time from the ICE audit. But definitely the public company, the company that has to report to the SEC, the private company that has to report to the SEC, should remediate at a period of time before a NOI is issued. Greg, do you have some perspective on what the future of external auditing is going to look like in your practice?
Well, I think I've just seen over the last couple years, and we can thank the uptick in government auditing for this, that it has become more and more of a focus in areas or with clients that were not as concerned. You know, frankly, I see this in the context of either corporate acquisitions or due diligence. Immigration traditionally is maybe, especially the I-9s, have maybe been an afterthought, and now you're seeing that it's much more on the forefront. There's been several occasions where we've been called in to do an audit or review an audit in anticipation of a sale of a business. And as you pointed out earlier, with the introduction of SOX, we're going to find this to be more of an upfront issue, and more of something that is going to be considered kind of at the C level in companies than it has been in the past. That's what I'm seeing.
So in summary, audit, according to the auditor's checklist that's found in the book, remember to differentiate between substantive and the technical and procedural violations. You're going to do a physical audit and reference document cross-check. That's very important because the missing I-9s can be discovered by looking at the reference documents, payroll records. And that reference document list is also in the book. You're going to be able to discover a lot about your employment history of the employer by looking at the questions that the employer is going to answer at the beginning of the audit. And there's a list of those type of questions along with the type of documents that the auditor should request from the employer. Key things in that you're trying to develop, as we discuss, the intrinsic and extrinsic factors that will allow the auditor to look for the right types of documents. An example is, has there been an employment history? Has there been an enforcement history, rather, for this particular employer? Has there been a previous ICE audit? Has there been a worksite investigation? Have there been criminal charges brought? This is especially important, Greg, in the large employer where there may be many work sites and there may be a decentralization of the I-9 function. Have you seen that type of situation in your practice where there's a decentralized I-9 archival?
Yes, or there's really no I-9 archival. Yes, we've seen that where hiring, where I-9s are basically maintained and retained at the place of hire, not in a centralized place with the corporate headquarters, and that can present some problems. Of course, you know, one of the first things in the internal audit is helping the client call all the I-9s, so you can do that analysis and make sure that there is an I-9 for everybody on the payroll, and that they've maintained the I-9s per the retention requirements. But that is a problem of course, with the advent of the electronic I-9, that can be minimized or resolved, again, presuming that someone actually went through and did the I-9. We're also seeing that common problem would be I-9s stored, let's say, with personnel files. So that's usually, and I think you guys are going to cover that later, but that's a no-no. So it's definitely something that we see.
One of our colleagues has a very interesting question, and that question is, what if we realize, this is the employer talking now, we realize that there's a missing I-9. We've done the reference document check, we've checked the payroll records, and certainly inadvertently I-9s were thrown out. We thought, says the employer, that the retention rule really meant that after 3 years we could throw away I-9s. And now the auditor has discovered that there's a broad segment of the population in which there are no I-9s. What would be your advice to the employer, Greg, in that kind of situation where there are missing I-9s? It's done through inadvertence.
Right.
It's not done through criminality.
Right.
But certainly you want to run the statute of limitations. You want to recreate the I-9s, re-verify the I-9s. What's your advice to the employer in that kind of situation?
Remediate. It's better late than never, or assuming that you, in the case where you never had an I-9, or if you had an I-9, it's been lost or inadvertently disposed of, I would recreate the I-9 or go through the I-9 process again. Now, this will depend on whether the company, how you do it will depend on a few factors, whether the company still retained, let's say, the I-9 source documents, assuming that they did retain those at all. But it's a exercise of remediation. Of course, in redoing the I-9, you are not going to backdate anything. We don't want to go there. You want to make sure that the date of employment in Section 2 is correct and syncs with the employer's payroll records. But yes, you're going to go through, and we've had situations where companies have, on a very large scale, had to go back and redo I-9s. And that in itself takes some planning and some strategy, because invariably employees are going to want to know, well, I remember I filled out this I-9 when I was hired. I remember it had my address and my social security number. Where exactly is that I-9? So it's more than just having giving a bunch of pieces of paper to some HR folks and saying, okay, go and get this taken care of. It does take some planning.
Well, the HR manager is actually very, very cooperative in our hypothetical, and likes the idea of re-verifying, and has followed your remediation advice to use the latest version of the I-9 form, the 2009, with the unexpired document rule reflected in the list A, B, and C, and has sent out the recommended notice that you helped draft to the population of the employees. But one of the employees has come into the HR department very distraught, and he basically said to the HR manager, look, I'm a U.S. citizen, and I recall when I was hired that I did provide my U.S. passport, and I just don't want to do it. No, not only don't I want to do it, but I'm afraid that I'm violating the law by doing this again, signing the Section 1 attestation of the employee. And I'm wondering, says the distraught employee, whether or not you're also violating my rights as a protected class, a member of the anti-discrimination provisions of IRCA.
Well, good point. You can't over-document. You can't, for a discriminatory purpose, I should say, you can't require people to continue to establish, let's say, their U.S. citizenship. However, in this particular scenario, this has been done pursuant to directive from counsel after an audit, and we're also presuming that this is not the only employee in the workplace that's being asked to redo their I-9. So the employer should be able to show that there is no discriminatory motive here, and that this is done for a lawful and necessary reason in order to comply with another set of laws. So that becomes a delicate human resources exercise in managing this particular individual, explaining to them why they're obligated to do this, and that they're not the only person, and that employee should be directed to complete the I-9.
Again, the way Greg answered this question is extremely important for you to see the analysis. Number one, he showed that the employer is applying a policy uniformly throughout the workforce and without discriminatory intent. And that's very important. The reason why is because the employee has voiced an important concern. It could look like overpapering if that particular employee had been singled out. But if it's a general population and you've explained this, basically that employee is being asked to sign to bring in the unexpired documents under the current policy, and it has been asked to do this in a non-discriminatory way. What if, Greg, even after all that, in other words, you've explained it to the HR manager, and the HR manager has explained it to the employee, and the employee refuses to go through a Section 1 employee attestation all over again and to bring in the proper documents that will allow the employer to do a Section 2 verification?
Well, that would really, I think, depend on, well, I know I would tell the employer that you need an I-9 for every employee. This would be, to me, this is tantamount to an employee refusing to complete an I-9 at the time of hire. And we're assuming that we have, let's say, no documentation. We don't have the original passport or a copy thereof. If the employer permits the employee to not complete the I-9 and continue to employ that particular individual, the employer is setting itself up for a subsequent substantive violation for failure to have an I-9 for that employee, not to mention a bad precedent throughout the workforce.
Okay.
So,
very interesting. Here's one of the quagmires that you run up against in a remediation context. Number one, I submit to you that it's a paperwork violation that we're talking about, and that the penalty that the employer is subject to, remember, it was the employer's negligence that caused the problem. The old I-9 was destroyed inadvertently. Number one, I would submit to you that it's a good idea to try to get extrinsic evidence that a verification occurred. Perhaps an affidavit of the HR staff that conducted the first. The other part of it is that I would document that a request was made and that the employee refused.
right.
And there are reasons, but I wouldn't. The other thing that you might consider doing is writing to, depending on the size of the employer. As you know, there's a distinction on the jurisdiction of which enforcement arm has jurisdiction over that anti-discrimination. Can you talk about something about that jurisdiction?
The anti-discrimination provisions of IRCA are enforced by the Department of Justice Office of Special Counsel and to a certain extent by the EEOC. So you do have this interplay between two different agencies, and it is, as people have described in the past, it is a bit of a minefield for an employer to walk between enforcing and complying with the Department of Homeland Security I-9 rules, and also not running afoul of the anti-discrimination rules which are enforced by the DOJ. Now, if we took your scenario and the employer just terminated this individual for insubordination, if that was the ultimate determination, they may draw a claim from the individual, among other things, for unlawful termination. And one of the basis that the employee could raise is that they ran afoul of the immigration discrimination rules. Again, the Department of Justice may get involved and investigate that matter, because we're going to presume that this person is a U.S. citizen, so they're protected. They're part of the protected class that those provisions cover. But ultimately, the Department of Justice and the individual, if they're making a claim under this basis individually, are going to have to show, and this is again based on an amendment to the Act after IRA, that there was discriminatory intent in this regard, that he was terminated because of his immigration nationality, immigration status or nationality.
One possible solution to the problem might be to ask for an advisory opinion from the appropriate jurisdictional enforcement arm. So if it's the small employer, you're going to go to the OSC, Office of Special Counsel. If it's a larger employer, you're going to go to EEOC. I would ask for an advisory opinion. I would freeze any adverse action against the employee until you have an opinion letter back from either OSC or EEO. If you have a question, could you bring it to the microphone in the aisle?
I would also say that again, what we're doing is we're treading on we're treading over into employment law as well, and this comes up all the time. I mean, I can't tell you how many times that we're in the middle of a remediation, or there's an issue that comes up. It could be a Social Security no match issue, and lo and behold, the particular worker also has a pending workers' comp claim. So again, I mean, all these, you can't advise the client in a vacuum, so to speak, when there's other employment factors that come into play, and they're going to have to bring in employment counsel as well.
That's a good point.
Yeah.
Yes, we have a question.
In light of the exposure the employer may have, if this employee is a U.S. citizen and reports it to the OSC and the investigations that will follow that, are there any circumstances under which you would advise an employer to do the affidavit, not get an opinion, simply on a cost analysis basis, let this whole thing go? Under what circumstances would that be advisable, if ever?
That's an excellent question. Actually, the Virtue Memorandum does talk about the unavailable employee. And if it comes to an ICE audit, there is a provision in the Virtue Memorandum that gives remediative steps for the unavailable employee. And I would follow, if it's in the middle of an ICE audit, I would use those steps. And again, the real crux of all this is to lay tracks of non-discriminatory intent by the employer, not to take an adverse action against the employee, to show evidence of a uniform policy, document the problem, but also to document the unavailability. This employee has made themselves unavailable for the remediation. So really, the employer is, at least as to the Section 1 and to the documents that have been, or the attestation as to the documents that were previously verified, presumably. But that's an example of something that is in the Virtue Memorandum that perhaps is a wonderful way to show that remediation has been attempted, but has been unsuccessful because of the unavailable employee. Do you have a feeling about that?
I would also add that it's really going to depend on the context of the situation. How how large is this employer? Has this employer previously been subject to any sanctions? Is there any concern that there's the presence of unlawful workers, again, because maybe the employer had been sanctioned in the past? I mean, I think all that would play in to this consideration as to, you know, how you would counsel the client. You can do this, you can, as we've discussed, you can document this way, you could rely on the unavailability aspect and make that argument in the context of an investigation. But I think, again, it's the whole totality of the circumstances analysis as to how isolated is this, and what is the context of the I-9 audit in general, the state of the other I-9s.
I think that's an excellent point, because Greg, it depends on the context. If you're in the middle of a government ICE inspection, the best advice might be to the employer to go to your forensic auditor or special agent that's conducting the inspection and ask for their guidance.
Sometimes, actually, that's very convenient, because they will say, you know, in the context of an audit, if individuals are, after their investigation, are deemed to be unauthorized, in most cases there's a provision that someone can contest, and they'll basically verify for you, and you will get, eventually you should get in writing a statement from DHS that an individual employee is in fact, and let's say this employee is authorized, and then the problem is solved if it's sanctioned by, or adopted, I should say, by ICE in this particular situation.
And that could lead to a really creative, if you are in the middle of an administrative audit, it allows you to look at the context from the standpoint, you have the virtue memorandum that says after September 30th, 1996, that the creation of a missing I-9 should be something that should be able to be cured. But then you have an ICE policy that says that once a NOI is issued, that such steps, a substantive step, would not be available. But this, again, is a missing I-9 that goes to issues of timeliness.
Right.
So the argument could be that it should be something that should be considered a technical violation, and something that would be subject to the 10-day business notice. In that case, if you had a notice from the government that there was a missing I-9, and you went back to the employee and said, by the way, I have this notice from ICE saying that there's no I-9 for you, but it's the government's directive that this is a technical problem and it should be cured, perhaps the employee will have a different reaction when it's a government directive.
One would hope.
But then again, you also run the risk, depending on who your forensic auditor is or special agent, depending on the ICE field office, they may consider that a missing I-9. And if you look at your checklist, no I-9 prepared or presented, S1 is at the very top. But that's a substantive violation according to the virtue memorandum, and they might just give you a paperwork violation on that count. So the stage in which you're looking at the missing I-9 is important. If it's away from the NOI, remediate and prove unavailability, ask for an opinion letter, show evidence of inadvertent destruction of the first I-9 by affidavits or other extrinsic evidence. But it may be very clear to an ICE auditor that the missing I-9 should be a paperwork violation, and the employer would in that case take their lumps once a NOI is issued. Any other questions? I want to thank you very much. Again, this has been an eventful day for us, because this is the first symposium that really goes to external auditing, and you've been the audience and the participants in one of the first CLEs that goes to external auditor conduct. So I salute you and hope that it's the beginning of a wonderful subspecialty for you, and that you are able to help many employers become extremely compliant with their responsibilities under the DHS laws and related employment laws. Thank you very much.
Thank you.